Welcome to another episode of Conduct Detrimental. Dan Luss joined by Michael Kravchenko. Mike, how you been?
Good, Dan. It's good to be back. It's been scrambling a bunch. A lot going on in the background, I think, for the both of us. So I'm excited to spend some time with you this week.
So whatchamacallit? I guess I have. Sometimes I'm right, sometimes I'm wrong. I was very surprised that Stephon Diggs ended up playing in the Super Bowl. That was a surprise to me that a player with an open felony charge would compete in the Super Bowl. Let's just say, and Mike, you and I had some comments a couple weeks ago that it was somewhat odd that all of his criminal-related hearings were postponed until right after the Super Bowl. I would think, Mike, that Mike is the case. It's a Massachusetts charge, right? Massachusetts charge.
Yeah.
Correct. Yeah, I think he probably would have been better off dealing with that Massachusetts-based judge before he had a dud in the Super Bowl. That was probably a strategy that maybe backfired on him. I bet that judge is less inclined to be nice to him now. Fair?
Yeah, I would say so, especially after having to sit there through it. It might have been a little bit more of a struggle for them.
Yeah. Okay. Well, listen, Diggs has set an unfortunate precedent that a player with a felony can play in the Super Bowl. So we can make predictions, but again, we make decisions based on precedent, and that is one, for better or for worse. One other note, I made a nice post to Taryn Sharma on LinkedIn. He was very cagey and coy with what he was doing when he said he would not be on the podcast anymore. We can now say it because it's public. He has joined the legal office. He is now legal counsel of Seattle Kraken with the NHL. So congrats to Taryn. If you love Taryn, send him a message. We're going to miss him, but we're obviously very happy for him to get on to his next endeavor. But I wanted to say it on the podcast a month ago. He gave a very weird comment that he's working in the industry and he's going to listen to this. So I thought that was a weird way to phrase it, but we're very happy for Taryn. It's a very good thing. So all good. We'll call this again the call to arms to the extent you want to be involved in Conduct Detrimental in some way, shape, or form. Always looking for people to contribute. We had a flurry of articles over the weekend. We are continuing to revise and update our processes so that people are getting enough play when they write an article or something like that. But Mike, you are a man that is paying attention to all those issues, correct? Fair?
Oh, yeah. I'm trying to run the show and definitely looking for some support on that. Anyone that's interested in, any of the background with conduct or with anything in the sports law world, it's definitely been great. Made some really great connections and been able to get some good skills and do something that, I never have before. So I definitely would highly recommend and appreciate anyone who's interested to reach out to us.
So I'll say this, and then we'll get into the topics because we've got to give the people what they want. Today we're recording this on Thursday, February 12th. Yesterday I gave a presentation, fireside chat, whatever you want to call it, to a group of MBA students at NYU Stern, and there were questions like, what can we do to network, and how did you do your path? And I know I've told our OG listeners for years and years and years, publishing, writing, this and that, but you don't have to be like a law student to do that. You could be a young lawyer, you could be on the MBA side. So Conduct Detrimental as a website exists for people to say they are quote unquote published in a particular discipline. And if you guys get jobs through Conduct, like, that's great. No strings attached. So I was talking to a contemporary of mine, on the sports finance side, and he was telling me how he was trying to get something published through a major publication, like a major website. And he was having a lot of issues. And I'm like, dude, if you want to get something published, we are a lot less stringent. And I promise, being published is being published. So you could be young, old, new, MBA, JD. If you have something that you think you can write about, and that thing that you are writing about you think has a little bit more luster, right? No pun intended, from being published on our website, we would like you to do that. We want to help you. And I'll say this, and then we'll get to the topics. Every once in a while, you're looking for an excuse to brag about something. Hey, I was published. I gave a presentation here. Appeared on a podcast, however you want to phrase it. Being published is a really easy thing to send to your top 10 contacts. Be like, hey, I was just published in this thing. I wrote this great article. Check it out. And the worst case is that they don't respond. And the best case is that they read it and they see how smart you are. So that's my advice to you. I've said it however many times over the years. I will continue to say it. There's no shortage of just kicking ass and hustling. So that's it. That's it. Okay, Mike, are you ready? Are you ready?
Yeah, we got a good lineup today. I'm very excited.
Are you ready for this jelly, Mike?
Let's hear it.
You know what that's a reference to?
I don't.
Well, you're not ready for this jelly, so it's okay. Okay, here are the topics for today. We're not gonna belabor it. 4 topics. I'm very mindful of the fact that we cover a lot of college sports issues, but we've got to cover college sports issues. So first topic today is gonna be player eligibility. We have dueling things. I don't know how else you want to put it. Dueling hearings, petitions, requests from 2 players of significant relevance to our college sports landscape. That is Trinidad Chambliss, former quarterback for the Ole Miss Rebels. Maybe by the time that this recording got to you, will no longer be the former, will be the current, but we're going to talk about his eligibility case that's right now, as we speak. You can check out my Twitter feed. There's some fun clips of it. But as we speak, it is being fought in a Mississippi courtroom. And then we have the curious case of Charles Bediako, who was supposed to suit up for the Alabama Crimson Tide. He's a player that had a 10-day contract in the NBA. But that eligibility case has been decided. Maybe it's not quite dead. We'll see if there's any further action on that front. But we have some updates on that as we covered it last week. So that's player eligibility. That's going to be our big bucket. Then we're going to steer away from college sports for the next 3 topics. That is Dana White in the UFC. When we have a head of a league sworn testimony, and the testimony is an inference or basically an argument that he's lying about something, and he could be hit with perjury charges, spoliation, all that fun stuff, right? Sexy words we don't get to say. We're going to cover it. We're probably the only podcast in the world that is covering it, but we are nerds, and it's interesting. Gavin McKenna, the presumptive expected favorite to be the #1 overall pick in the NHL draft, was charged with aggravated felony assault last week. Charges have since been dropped. When we say it's dropped, that's like buy the rumor, sell the news. Like, it's not really dropped. It's not a felony anymore. It still could be a misdemeanor assault. But we'll cover Gavin McKenna. And last but not least, you know me, Mike, I get news push notifications on a lot of stuff. One of the things I get push notifications on is TMZ sports updates. And I saw this crazy story with Jaxson beating up the Mascot, and then the same lawyer that when defended her, I guess was representing his significant other, is defending the Mascot. I'm like, okay, this checks all of Dan's boxes, so we're definitely going to cover this. So 4 very interesting topics. We're going to cover them all. We'll see how quick we can be. I'm away next week on a little vacay with family. I'm obviously working, but not going to be recording the podcast. We wanted to make sure we had a pretty robust episode. We missed last week with some drilling issues. I, for one, Mike Krepchenko, I blame the other Mike. Fair?
Sure, I'll jump on board.
Sure. Love Mike. And he's not here to defend himself. So let's see if Mike listens to the podcast, and then he can give himself a fair defense. So, okay. Let's get rolling. Before we do, podcast sponsored by Themis Bar Review, the top bar company in the galaxy. We've kicked up, shout out to Gwen. We're kicking up back our newsletter sponsored by Themis. We're doing a lot of cool things with Themis. We are, I don't want to say anything, but it looks like it'll probably be March. We're going to have another happy hour at some point soon. It might be co-sponsored. I don't want to say co-sponsored. Actually, I think I could just say this. If you're in the New York City area, this is not sponsored by Themis, but Themis is we've had some talks with Themis about doing a kind of symposium event. It's not quite right yet for us to do, but if you're in the New York City area, I'll say, I think it's, I'm not going to say it out here, right? I think it's Thursday, February 26th, and you want to come to a sports lawyers specific event. I think we're just going to a bar. I don't know if there's any dram shop ramifications or any type of issues, but if you're in the New York City area and you want to come hang out, all you have to do, find me. Send up the bat signal, and if I don't respond, follow up at least twice, because I am a mess. Mike, how many times do you have to follow up with me before I respond to things? Yeah,
usually once or twice, that's for sure.
Once or twice. But don't just email. If you just text me once, I know you're not that interested. If you email me twice, you're a little bit more interested. 3 times, like you're so super interested, of course you're going to get the invite. There's no barriers to the event. I don't think it's not like we're not paying for drinks or anything. Just we always are looking for people to meet one another that are in our little worlds. I do not love the professional groups that charge you to like hang out with people. We don't do that. So probably could make a lot of money if we ever did that, but it's not what this is for. We don't have Patreon. We just have some fun stuff. Okay, Mike, 10-minute mark. We've done all the housekeeping issues. Can you tell me what's going on with Charles Bediako?
Yeah, it's something we've been covering pretty close. So, very brief background for those that haven't seen it. He's a former professional athlete at the end of the day. So Charles Bediako had originally played 2 seasons at Alabama before declaring for the draft in 2023. Didn't get drafted, but he did sign professional contracts. So he had some G League stints with a number of teams. And so he felt, a lot, this conversation has been going on across sports now, really. And it's mainly been focused in basketball, where players are interested in going back and remaining within their, 5-year NCAA eligibility clock. And he's technically, in that. So he sued the NCAA for injunctive relief to actually return to college basketball after seeing a number of other people either do it or try to do it. And at the time, the Tuscaloosa judge actually issued a temporary restraining order in late January 2026, which we covered. So it allowed Bediako to play. And in that time, he's appeared in 5 games. I mean, averaged decent numbers. I mean, 10, 4, and 1, not the greatest, but he existed and played on the court. And Alabama went 3-2 over that time. So there's a lot of questions as to what's going to happen with that, because as of the beginning of this week, that same judge denied Bediako's motion for a preliminary injunction. So it allowed the NCAA to actually enforce its eligibility bylaws, and he's now ineligible again for the rest of the season. So played 5 games. It'll be very interesting to kind of see how that spurs up, because they moved up to now the projected number 4 seed, I believe. So it's, March Madness is right around the corner, and it's going to be interesting to see how those 5 games are treated, because it'll really focus on, who's available for the NCAA tournament. And even wins in games where Bediako played are likely to count on Alabama's record, just because the NCAA selection committee evaluates the current rosters, and really they haven't imposed any sanctions and there's been no internal NCAA discipline. So that would be separate. So in terms of, I know that's a big question in the market right now and in our sports world, of what's going to happen with March Madness, and is this going to impact it? As of right now, it's not, but it's been very clear, I think, how the NCAA and SEC commissioner, even Greg Sankey, filed an affidavit supporting the NCAA's position on eligibility rules and how they should be upheld. So there's been that stress between, and we've talked about it on the podcast. I've been pretty open about how I feel about it. There's a historic boundary there between college and professional play, and he played. At the end of the day, it's not just about like his specific eligibility. It's just the fact that he signed a professional contract, and that normally historically has disqualified a player from returning at all. But here we're seeing, and we'll get into it with Chambliss as well, and there's a couple others on the headlines, that the NCAA hasn't been very consistent with how they've been ruling eligibility and dealing with that. And this is by far not going to be the first or the last, but if it does hold, on here with this appeal and in future cases, I think it's starting to solidify a little bit in this new era, that at least at the bare minimum, former professional athletes who return to college just cannot circumvent the NCAA eligibility standards. So while there's conversations, we'll talk about Chambliss with maybe health or JUCO or whatever the situation is, this one here, I think we're starting to move a little bit in the direction of a clear structural decision that if you play professional or sign professional contracts, you maybe not be able to come back and play. And for me, I think that's, a win, at least, personally. I think that's, as we've seen with across really basketball for the most part, trying to come in after pro experience. We talked about it earlier, that James Najee's timeline, he technically, playing for Baylor, has been permitted and continues. So that's a little tricky as well. But at least here on the Bediako, we needed to give an update as we've been covering it pretty extensively over the last number of weeks, really month. So as of right now, the full update is that he is no longer eligible, and we'll see what that does or means for Alabama moving forward. You obviously can't go 500 with 5 games, but they went about 500 with him. It doesn't seem to have impacted them too badly outside of what the viewpoint of I think a lot of people when going into March Madness, we'll see how favored Alabama is and how this all impacts them. But as of right now, Bediako is again ineligible as we continue to just, go down the rabbit hole of eligibility, both in basketball and football.
So the linkage here is interesting. So listen, we I don't know, like, again, I had to, when I was talking to NYU last night, I had to be very like, I'm not really like, I'm never going to be pro NCAA. It's a very weird hill to die on if you're pro NCAA. But I'm certainly of the opinion at some point we have to draw the line somewhere, and and it'll kind of dovetail into this Chambliss conversation. But like at some point, the NCAA or a state court judge has to be not afraid to enforce common sense. Like we can't just have every court that we go into that's going to be, like fill in the blank, like Duke, right? For Durham, North Carolina, the judge is going to have a favorable ruling to Duke. Like it's just time and time again. So Bediako is kind of like, Mike, what court was it in? Do we have the county for the Bediako case?
Yeah, it was in Tuscaloosa, the county circuit court, actually.
Okay. So let me get this straight, Mike. A judge in Alabama, in the Tuscaloosa Circuit Court, basically rendered a decision that was adverse to Alabama. Is that what we're saying?
Oh, that's right. And there's some juicier information about him too.
Wait. Let me ask the tough questions. Okay. What school did this guy go to? Clearly, he's not an Alabama alum.
Well, that's the thing. Undergrad, University of Alabama alum.
Where did he go for law school? Like Auburn?
No, Faulkner Law, also in Alabama, but
yeah, this guy. Listen, credit. What's the guy's judge? What's his name?
Yeah, Daniel Pruitt.
Oh, good first name. So we have an Alabama judge who's an alum of Alabama rendering a decision against Alabama while he lives in the state of Alabama. Power to him. Power to Daniel Pruitt. It's the first kind of high-profile case of its type where a state court local judge, a judge sitting in that state. Again, I actually did not know that he went to Alabama, but even more surprising, has ruled against the school. So, I wish Daniel Pruitt and everything all the best, because I'm sure he's hearing it everywhere he goes that he ruled against, Alabama in his home state. But that notwithstanding, like that's been the issue. That's been the issue for all these cases. Home court is cooking everywhere. Anytime the NCAA gets challenged, all this, it's just, that's not how we should be litigating these cases. That shouldn't be the decider. But then again, we are not, I'm certainly not here to like say that every player, like every case, that the reason a player should win or lose is because of where the case is filed. It should have something to do with the merits of the case. So while Charlie Baker could go out and say, I don't think a player that signed an NBA contract should play. I think to the casual fan, a player like Bediako who signed a 10-day contract, I don't think the casual fan knows the difference, and maybe there is no difference, but it's just odd that was, wherever the home court was who won the case. So Bediako has been denied. I'm not going to say it's good or bad. I don't want to get in trouble, but it's a decision that is only really relevant. Mike, correct me if I'm wrong. It's relevant in Alabama, in that jurisdiction, right?
Yeah, I mean, as far as I'm concerned, yeah, and March Madness.
It's not really binding precedent. It's not like,
No.
It's not going to control the other jurisdictions. So anyway, keep that in mind. File that away, I guess, over here, right on the left. We have Bediako losing. So we have the 10-day NBA contract guide. It doesn't mean that a different state's going to have, again, it's not binding, but it could happen. But we have one decision point. So I have flagged this one to my students in my classes. And I've said, similarly, like we have Bediako having an issue in Alabama. Okay, so Alabama gets denied. Bediako, we're not having guys who play in the NBA play in college again. Cool, got it. Just for Alabama, but it's at least helpful guidance. So Trinidad Chambliss is a really interesting one. There's a direct through line between these two cases. So Chambliss gets his, he applied for another year of eligibility. We've talked about in the previous podcast that he had some. I don't really, nor do we need to understand this fully, but some type of COVID-related tonsillitis that caused some issue in 2021. It's a whole story, but there is a question as to whether that was a true medical redshirt year. There's a question, and I'm not taking anyone's side. There's a question as to whether Chambliss actually had received that medical redshirt year at the time, or if he's just asking for retroactive help. It's a question as to whether he actually made the request at the time, or it's all just all retroactive. In which case his case isn't as strong. So I've seen everything on Twitter. There's some stuff in the news. But his old school, what is it? Ferris State, was that his school?
Yeah, Ferris State in Michigan.
Yeah. Ferris State was claiming that they didn't have records of it, but there are records of it. It doesn't really matter. It doesn't matter because that's not why we're bringing this up here. We're bringing this up because the NCAA denied it. And then, as the powers that be would, that case then got challenged in a Mississippi court. Mike, as we sit here right now on February 12th, 2026, that case is being litigated literally this very second in a Mississippi courthouse. If we are to look at 99% of precedent, not including Charles Bediaco, 99%. Mississippi court, Mississippi judge. Who do you think is going to win, Mike?
I would say Ole Miss.
I would say Ole Miss. That's just home cooking, right? Like the home team gets, they used to get 3 points. Now they get like 1.5 for our football games. Like favorites should go to the home team. That's where they filed it. I did want to put a little color on the procedural history of this case, which I thought was really interesting. So I don't want to get too in the weeds, but when the weeds are interesting, the nerd in me pops up. So friend of the show, Tom Mars, is co-counsel on this case, and Tom's been on the show a number of times, whatever. Tom is on the case, as well as an attorney named William Liston. Mike, do you know who William Liston is?
I don't off the top of my head, but why?
So William Liston, at least as far as I'm aware, as far as the internet will take you, seems to be the GC, practicing attorney at Ole Miss or Mississippi. Again, it seems to be what's out there. Hopefully, I don't get in trouble. But he is very closely affiliated with the Grove Collective, which is Mississippi's collective. So I have thoughts on this. If you don't have thoughts, and I'm definitely not trying to get in trouble. Do you think that this is interesting? Yeah, I think this is public. This is fine. It says it on his bio. William Liston, founder and general counsel of the Grove Collective, an old Mississippi exclusive name, image, and likeness program for intercollegiate student athletes. It's on his website bio. Okay, so he's the general counsel of the Grove Collective, and this lawsuit is being handled by two attorneys. Tom Mars is, for our purposes, I think, independent. It's fine, but it's William Liston, who is the general counsel of Mississippi's collective, suing the NCAA on behalf of a player. I have an opinion on it. We'll see if you want to venture out here. Do you think there's any potential conflict of interest here?
Not off the top of my head. I'm interested where is your brain going with that?
You thought I was going to say something I was not. I don't think it's a conflict, but it was interesting enough that I had to think about it for a second. So we have a player who, in theory, right, and I think it's somewhat reported. I don't think the number is official, but a player that the case right now that he's going after Ole Miss for, or he's going after the NCAA for, is like, hey, I have irreparable harm unless I've granted eligibility. And what's my irreparable harm? I have a contract, $5 million contract from, in part, this collective. Some of the fees are going to the collective, if not the vast majority. I'm sure there would have been rev share money under Ole Miss as well. But this contract I'm going to lose, and I have irreparable harm unless I'm granted eligibility. And meanwhile, his lawyer is the lawyer for the Grove Collective that generally would have drafted this contract, or otherwise would have been involved in the contract as a general counsel of the collective. So while the Grove Collective is not a party to this lawsuit, they are very much related. They're very much interested in this proceeding. So I don't think it's not a conflict, because the Grove Collective certainly wants Trinidad Chambliss to play. It's not a conflict in that sense. It's just that there's commonality of representation in the parties involved. So I thought that was noteworthy. Hopefully Tom doesn't listen to this and send a message to William Liston to say I was saying anything bad. Not really. I just find it interesting, and I will say that, of course, they filed the case in Mississippi because that's the only appropriate venue for a Mississippi case involving some type of action involving the eligibility of a player to play in Mississippi. Like, of course, they'll file it there, and I think the odds are, of course, stacked against the NCAA in that court. So I'm going to read a comment from Trinidad Chambliss in the closing remarks that Ross Dellinger, I think Ross is with Yahoo. Yeah, Ross is with Yahoo. This is a quote from Ross, who must be at the hearing. Quote, Trinidad is not a professional athlete trying to come back to college. It's absurd to me that a professional athlete would try to come back to college. Mike, who do we think that William Liston is referencing in that closing statement?
I would say the gentleman we were just talking about, Bediako.
Bediako. We have some fighting, right? Like, we want eligibility for Chambliss. He had a medical issue, this and this, whether he was put him on notice, this and this. But the guy didn't go to the pros. Like, that's crazy. How dare someone that go with the pros? Like, so now we have kind of this, the first time that, at least as far as I can tell, that we're seeing it, where the eligibility people are not like, they're not all saying let's open the floodgates entirely. They're kind of pointing at Bediako, and this is listed here, and saying we should not allow additional eligibility. So it's interesting. It's interesting. Like, this is our first kind of point of demarcation where, like, all of the eligibility lawyers are not saying let's open up the floodgates. You have Chambliss saying, look at this guy Bediako, and we are not him. His, he's not saying this, but his was rightfully denied. Like, ours is a good case. I just thought it was noteworthy. And there's don't read anything into it. Interesting. I try to find things that are interesting. Like, are you intrigued? Are you intrigued by this?
Yeah,
give us something, Mike.
I think it is. No, 100%. I think that this is gonna, like we just talked about, it may only be in Alabama, but I think it's setting a precedent for how they handle eligibility as a whole. I mean, there needs to be some structure in place. We can't just have, 50 players in off season or even in season suing for these things, and the NCAA also needs to be, consistent with it. And there are lines, and I feel like similar to how they've been handling NIL as a whole, there's just been kind of a free for all in the courts, and the eligibility needs to come back down to earth and have a structure. And I think that Bediako and eventually Chambliss and Pavia's already been talked about. There's going to be a lot of intertwining and a lot of conversation, I think, in the courts about each player's situation. They're going to continue to use a Pavia situation or a Bediako situation as examples. The precedent's there, kind of.
Right. So I guess we'll put a pin in this, and then obviously we'll follow this. I think the odds are very much stacked in Chambliss's favor in Mississippi courthouse. What will be interesting, and again, like, that's not going to shock anybody. Do we think Chambliss is going to prevail? Yeah, well, let's see, right? Like, but that's just Mississippi, and Bediako is just Alabama. What will be interesting is, and again, following Bediako, now we have our first real decision point on a very big name player being denied. Whether how persuasive that precedent is within the state of Alabama, and vice versa. How persuasive is the precedent going to be in Mississippi? But this is why no one in the world is in favor of state by state guidance for all of these issues, because, like, we don't know what the next answer is, and that's not really that good. Mike, I'm ready to move on.
I think that's fair. Yeah, there's a lot of eligibility conversation, and it'll be next week, the weekend. Like, all these, this is a topic that is, I think, needs to eventually come to a close, but it's top stories. They gotta be talked about. I had my we'll move on this note. Like, I do 2 classes of college sports, right, to start every semester for whatever law school I'm teaching at, and I can tell after the second class, I got a lot of questions. I got glazed over looks. I'm like, guys, this is the hardest thing, and I have to do it first because these issues are going to pop up during the course of the semester, and I have to have you aware of it. Everything else after this point is much easier. Like, be it intellectual property or this or criminal or civil, whatever we do in sports, like, this is the hardest stuff. It only gets easier from here. Same with this podcast. It only gets easier from here. Okay, Mike, let us move over to Dana White. Mike, on a scale of 1 to 10, what is your UFC fandom? 4, I would say.
4?
Yeah, I like to watch. I respect the sport. I don't find myself on Saturday nights putting any action on it, or definitely, finding whatever streaming service it's currently on.
Well, it's on Paramount, so.
There you go.
You're welcome.
So he's a streaming service.
Okay, so I'll explain this in as deep a way as I can. We, at least in the era that I've been covering sports very closely, I don't recall any hearing that's made it publicly where a commissioner or the head of a particular sport is being accused of spoliation, perjury under oath, lying, hiding evidence. Like, it was pretty sexy, and I have not really seen mainstream media covering this in a way that I think deserves to be covered. But then again, we are still waiting for a decision from this judge, so it's possible you're going to hear a headline in a week or so. And there's something that just happened, which we'll talk about, but you might see the headline and you'll be like, like, was anybody else covering this? Did anybody say anything about it? And we have said it. So, whatever it is. Okay. So let's talk about it quickly. There is a series of antitrust cases that was filed against the UFC. You heard about some of these. We covered it briefly. We haven't done like a full breakdown. I've been trying to recruit the UFC. There's 2 UFC lawyers I really like that I'm trying to get on, and it is what it is. They're in Canada. They're in this. They got a bunch of issues. We'll cover it when we need to. Maybe when there's the Dana White. Maybe if there's a lot of mainstream coverage, we'll bring someone up. Whatever it is. So Dana White was called in. There was a series of hearings in front of this Judge Boulware. And Mike, what court is this in?
It's in the District Court of Nevada, of course, with UFC. Okay.
Peter Boulware. There's a series of antitrust cases relating to the UFC. So they're all, at least for purpose of us, we're in Nevada federal court. So there is an issue in this case about, to the extent, what is the monopoly power of the UFC? Do they exert too much control? But just understand, like, UFC is being treated as independent, their fighters as independent contractors. There's a debate between employees and independent contractors. And the question that is before the court, we want to see text messages from Dana White as to his conversations with fighters for a particular period. So, it is what it is. The UFC, again, doesn't produce sufficient text messages and communication to the court's liking. And they bring in everybody. They bring in, the entirety of the brass. They bring in Dana White. They bring in Hunter Campbell. They bring in Tracy Long, who is Hunter Campbell, people know, is like one of the main matchmakers. He's kind of like the guy behind the scenes. And then Tracy Long is VP of Athlete Compliance. So she's somewhere in the legal department of some sort. But they bring in all these people and they want to figure out, where are the text messages? Where are Dana White's text messages? So Dana comes in, and this is last week. So this is February 4th and 5th. There's been a series of hearings, and we have an order that has come in from Boulware, which, again, we'll figure it out. So they've seen a number of texts, and this has come out with other people that are not Dana White, and Dana is texting somebody something. Doesn't really matter, but there are texts that have been produced with person A and person B. Okay? So text between, Mike, for example, text between you and I. Okay?
Sure.
And they look at my phone and they see the text from A to B. And then they go to your phone, Mike, and they're like, whoa, this doesn't have the text from you to Dan. It's like missing a lot of stuff. And without getting into all of it, this is why you have forensic accountants to look at the cloud and any number of things, try to recover the text, blah, 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 blah. So they asked Dana, why don't you have those text messages for that particular day? Like, we need to verify that those are the only texts. And if anything, Mike, we need to verify whether the text that I sent from me to you, Dan Lust to Mike Krivchenko, those should be the same text messages that are available on your phone. But if they only have my phone, they can't really verify whether those are the entirety of the text messages. Fair?
That's valid, yeah.
So Dana White gets on the stand. I believe this was February 4th, so it's about a week ago. And he essentially says it was an iPhone 11. The phone was lost. I'm not tech savvy. And by the way, I'm not really even involved in fighter negotiations. Like, I'm not really involved in this. Ever since the company changed hands and they changed ownership, I'm not involved. I'm just kind of a figurehead. And, by the way, I don't have the phone. Even if I was involved, like, which I'm not, and none of the texts are relevant because I'm really involved in this process. Like, I'm an Instagram DM guy and, like, whatever. I'm not involved in this process. I don't have the phone anymore. The phone is gone. And so, the questions that the lawyers for the fighters asked are like, well, where's the phone? So I'm summarizing, but essentially the testimony was the phone wasn't destroyed. It was put in a cabinet, a mysterious cabinet. Okay.
Interesting.
And the cabinet does not have said phone anymore. So that's the gist of the testimony. And there's some question about whether someone might have stolen the phone, because this person was stealing other stuff. So maybe someone stole it. So whatever you want to say, it's a dog ate my homework, right? Like, it could be anywhere. It could be lost. It could be this. And even if we find it, I'm not really that involved. So none of these text messages are relevant. You follow me so far?
Yeah, no, absolutely.
So I don't know, Mike. Dana White definitely doesn't listen to this podcast. What do you think, Mike, about these series of various excuses and deflections?
Yeah, it's a little tricky. I find it hard to believe that I mean, that level, you don't need much tech savviness to preserve text messages or reset your phone as a whole. I know that not all text messages, I guess, could be backed up, but like you mentioned, there's a lot of alternatives to go just beyond, going through the messages app and finding it. So very strange to me that the phone had, I guess, been somewhat replaced or reset, and then it's kind of, I know that, I mean, this is probably what the plaintiffs are arguing as a whole, is like it's on the side of like spoliation of evidence to me, and it's like you're kind of in a way destructing or potentially relevant information after litigation was already either anticipated or I don't know if it was taking place yet this far, but it's tough. I find it pretty difficult to believe that it just disappeared, or that those are just not, that the records are completely lost. Now, an iPhone 11 is some years ago now. It's not yesterday, but it's not a Nokia phone that or a one-off burner device. So those text messages should still be preserved somewhere in some place. And it all just sounds very suspicious. The whole cabinet thing. We're watching through Sopranos right now and finishing it up, and there's things hidden in the house. I find that it's just not. It's hard to believe that there was just a cabinet with this phone that now it's gone. And to me, it sounds like probably like what the plaintiffs are thinking. A little bit of spoliation of evidence there, but I'd love to hear.
I'll echo that. I think it's almost in this day and age in 2026 harder to like delete text. Like the cloud stores everything, so it just I'm with you. I think I gave you a softball there. Like it's almost impossible for like you to have preserved no text. It seems like a decision was made, right? Like it seems like the texts don't exist because someone didn't want them to exist. So again, we have no idea. We're just looking from our ivory tower. So Judge Boulware listened to testimony from a couple of different people, and a directive he gave. He wants some evidence of this cabinet. He wants the cabinet. He wants to figure out this cabinet. Like he wants some to look into the drawer. He wants some photographic evidence about this cabinet situation. So allegedly that was supposed to be provided by, I think it was yesterday, February 11th. As far as I can tell, there's been no update on that. So let's see if they provided or didn't provide it. Whatever it is, I think Boulware is correct to be dubious of the collective testimony. And the question really is going to amount to this. Let's say they had a duty, and again, for those that are new to the podcast or new to common sense, if you think litigation is going to result, or just like you think that these texts will be relevant in some way, shape, or form, if something was just like destroyed or lost in the ordinary course of business, like, it's not an issue. But the question is intentional or reckless spoliation. If something is going to result, like when and how did you lose control of this thing? If you put a phone in a drawer and someone steals the phone, I guess that's not really spoliation, it just kind of happened. I still find it odd that there's no cloud and all this other stuff, but neither here nor there. The question is, what will happen if Judge Boulware believes that spoliation attached? And that's we would result in what's called an adverse inference, which would be the most severe result. There'd be sanctions, there'd be this, but there'd be this inference that to the jury, I'm not sure if this is jury hearing or a bench hearing, but there'd be an inference that the text messages don't exist anymore because they contained really bad things on the text message, be it Dana White forcing, using leverage to make fighters accept less pay, right? The question is whether this is a monopoly. So I find it, it's a big revelation. I listen to a lot of UFC podcasts. I don't think people knew that Dana White had no involvement in the fighter negotiations. I think people understood he had phased to the background a little bit, and that Hunter Campbell and other people had kind of taken the lead with kind of day-to-day operations. But it was news to a lot of people how little Dana White was involved. And I think that's what Boulware is, latching onto, that seems odd. So, if Dana White gets hit with an adverse inference, that could be really bad for the UFC, good for the fighters and the plaintiffs in the case. But we, got to watch it closely, right? And if Dana White is found to have lied about this, right, in some way, shape, or form, cabinet doesn't exist or whatever, however they phrase it, like, it's a much bigger issue. So again, it's not really news on February 12th. I promise it will be news if Dana White is told, is directed, or there's an order that's saying he perjured himself under oath. That's very different. And we hear from a lot of fighters at that point. Mike, final words on this?
No, I think you wrapped it up well.
Okay, I'm good with it. Okay, let's move on to our next one. Let's do these as quickly as we need to, and then we'll get out of here. I'm having a very late night at the office tonight, so the sooner we can finish this, Mike, the better. Okay, Gavin McKenna. Mike, I have talked a lot. I'm going to let you, as our resident hockey guy, tell the world about Gavin McKenna, hockey player.
No, yeah, I mean, I'll take that title. I appreciate it. My Rangers were horrific this year, but I'll definitely take it. Been enjoying the Olympics, but yeah, Gavin McKenna. I mean, the projected number 1 overall pick has been talked about for a number of years now. Penn State. This happened kind of in relation to Penn State. So we're going to go off of today. Obviously, we're recording February 12th. As of right now, like you had mentioned, it's a little bit. The headlines will tell you one thing, but if you do a little bit more searching, it is a little bit different. So Gavin McKenna, though, he's an 18-year-old forward from Penn State. He's been on the team for the last number of years, and he also played 3 seasons in the Western Hockey League. So he's the projected number 1 overall pick for the 2026 draft upcoming. And the reason why I bring up Penn State specifically is because this took place in State College, Pennsylvania. So Penn State had their unbelievable outdoor game. I mean, tens and tens and tens of thousands of fans, at Beaver Stadium. And it was just an incredible sight to behold. But immediately following that next day, it occurred right after the game, actually, in Beaver Stadium. But so McKenna was involved in what is being labeled as an off-ice altercation outside a downtown pub. So the initial police reports and why this was such a huge deal was that McKenna had allegedly punched this man in the face twice, and there was jaw fractures that required surgery, and he was immediately charged with felony aggravated assault, misdemeanor simple assault, disorderly conduct, and harassment. So it's interesting that aggravated assault charge alone carried, a potential prison sentence up to 20 years under Pennsylvania law. So this was a possible future megastar, career over before even being drafted. Up to 20 years is unbelievable, right? You'd think so. As of this past week, why I said the headlines maybe will tell you one thing, and it's a little bit different, when you look into it a little bit more. So on February 6th, the Center County District Attorney's Office officially dropped the felony aggravated assault charge against McKenna. So that is just, they've reviewed the video evidence and concluded it didn't support the level of intent or recklessness that was actually required for felony aggravated assault under the Pennsylvania state law, like I mentioned. So the video did show that there were punches and injury, but not conduct that indicated any sort of intent to cause serious bodily harm or, an extreme indifference to human life in this situation. I wasn't there. The video is the video, but altercations happen outside of pubs and bars consistently. And it's, here it showed that there was just no serious intent on his end. So that's really where the felony charge comes into play. But he still does face the lesser misdemeanor simple assault charge, along with also the summary disorderly conduct and harassment charges that we mentioned. So that is not completely off the table. He's still projected number 1 overall pick, still, expected to return to play with Penn State upcoming. So the preliminary hearing for the misdemeanors is scheduled for March 11th of 2026. But in the meantime, up to March 11th, he's still expected to return to play with Penn State, and they even have upcoming games this weekend. So he's going to be playing Michigan as of actually the day that this gets released. So, there's still play. He's still going to play. Still, I think his draft stock is going to continue to stay kind of where it is, depending on his play on the ice, of course. But NHL scouts know, the NHL knows, obviously, and he's the leading draft prospect. So it, of course, was going to draw significant media and fan attention. It could have tanked his draft stock. We've seen things much less crazy or much less violent knock some people down on the draft across all sports. And it's possible that there's going to be NCAA or league conduct considerations, but as of right now, there's been nothing. So what we're at is the obviously he was charged with the felony, but that's since been dropped by the prosecutors on February 6th. And now he'll be going to a preliminary hearing on March 11th for that lesser misdemeanor and summary offenses. But expected to continue to play and, likely still going to be the number 1 overall pick, barring any additional crazy evidence that comes out of this. But, it's a hockey player. So getting into a fight with a hockey player, I don't know. It's part of the sport. So I don't know how internally the league and the hockey market feel about it. I know my fantasy hockey group chat was buzzing for a few days, but that's where we're at with Gavin McKenna. Definitely still a top NHL draft pick, incoming for this next season. So we'll keep you posted, as the March 11th date comes around and moving forward, because the draft, I believe, is relatively shortly after that. So we'll see where it goes when it comes to either the criminal process or the league discipline as a whole. We'll keep you updated and definitely, maintain on the website for sure.
So, I think the big takeaway: felony aggravated assault for the number 1 overall pick, knocked down off of a felony, but it does not stop the player from being, we'll say, charged with a lesser offensive misdemeanor assault. At least it was supposed to be hearing, I think it was February 10th, but they've adjourned that. So we'll see what we get. Similar, and again, try to be consistent as much as we can. If we're saying that Diggs has a felony and shouldn't be playing in the Super Bowl, I would hope that the draft stock of one Gavin McKenna would suffer because of a felony charge, and the difference between a felony and misdemeanor, obviously the severity of the charge, but as the results as at least the reports are coming out, it seemed to be, we'll say, a lesser offense. So while it got headlines of felony assault, there have been players charged with misdemeanors in the past. Misdemeanors punishable by up to 1 year in prison. So it's a different offense. It doesn't mean that the guy is a squeaky clean guy, but it's not necessarily the nature of a felony, which obviously by the definition of a felony could make a player unavailable for a much longer period of time, and it's a much more serious offense. So watch it, but that's nature of the beast. Okay. I have an interesting update. We'll see if we have an update while we're on the podcast. We're going to be recording another handful of minutes. So I'm getting all these notes, Mike, from people at this Chambliss hearing right now. And this judge is in the middle of reading this decision. And he's still reading it. It's like a 20-minute decision. I don't know what, we haven't really heard what the decision is going to be. But interestingly, per Amanda Kristovich of Front Office Sports, friend of the show, has been on a ton, was on somewhat recently. The NCAA lawyers left. They're not there. So he's reading the decision to Chambliss's lawyers without the NCAA lawyers being there. And I guess there was some comment from the bench about potentially holding them in contempt for leaving. So plot thickens, and I would think that if the NCAA lawyers were leaving, that's probably not a sign that the NCAA is going to win. It might just be like a walkout and protest type thing, but definitely we're going to have the answer to this by the time I think the podcast is over. But in any event, let's do this, and then we'll do this update quick, and I think we know where the answer is going. There's a judge reading decision. It's been for 43 minutes. So I'm reading from Trey Wallace, who is a reporter for Fox. Judge Robert Whitwell is clearly laying the groundwork in terms of the NCAA ignoring medical evidence provided by Trinidad Chambliss. This is clearly for the potential appeal and further arguments past the 43-minute mark. The NCAA, quote, the NCAA provided no medical objection or opinion. So looks like Chambliss is going to win, but obviously we'll see. Okay, so let's do the last one, then we'll call it a day. I anticipate we're going to have a hearing on result on Chambliss relatively soon, but we don't need to hang around for it. So, Mike, Jaxson Hayes, what's your familiarity level with Jaxson Hayes, basketball player?
Very, very little until this story came out, which was very interesting. Has a little bit of nuance to it.
Okay, Jaxson Hayes is on the Lakers. He was a former first-round pick of the Pelicans. Somewhat of a I don't want to say the B word. He's kind of a bust. He kind of got his ups and his downs. There's a game, I think it was maybe the last week of January, and I've seen this clip where he kind of just decks this mascot for the Wizards. With Dex puts shoulder into him, it just seemed completely out of line. It wasn't like they hit each other by accident, it looked like Jaxson Hayes went out of his way to make contact with him in a way that harmed this mascot. Okay, we've covered mascot lawsuits before. I remember we covered the Conor McGregor lawsuit when he maybe I think it was a lawsuit. There was definitely some legal issues where McGregor KO'd some mascot of the Miami Heat game, and it wasn't, was it a publicity stunt? We didn't know. Blah, blah. This Wizards mascot, rest assured, is not doing a publicity stunt with Jaxson Hayes of the Lakers. Very different than Conor McGregor. And Jaxson Hayes looks like he's now being subject to this mascot lawyering up. Okay, whatever. It's an assault case. The guy doesn't look that hurt. It's the issue with this guy lawyering up. So kind of interesting. Probably wouldn't make it on the show until, Mike, we found out the lawyer that is representing the mascot. Mike, do you want to reveal this, or should I do it?
You got it. I love this. Is like TMZ sports law.
So it is it is TMZ sports law. I mean, it's by TMZ. That's why it's out. So Sophia Jamora is the name of a significant other that Jaxson Hayes was previously involved with, and who previously sued him for domestic violence. Okay, so that attorney is not just representing the significant other suing Jaxson Hayes for domestic violence, is now representing the mascot, likely suing Jaxson Hayes for domestic violence, for some type of violence, some type of assault. I don't think the lawsuit's been filed yet, but that's some degrees of pettiness that the SO has now found another plaintiff to sue the same guy. It's also somewhat rare that two different parties in two different incidents would find the same lawyer to sue the same alleged assaulter. So just outside of sports law, it's kind of rare that would happen, but she does have history suing Jaxson Hayes. So, I guess it kind of makes sense.
Yeah, I think we talked about it offline. It's a little bit of an interesting out of everyone that exists. This being the attorney, I'm surprised it's relatively rare, but I don't know. It's definitely a negotiation. I would say it's a tactic at the bare minimum. I don't know how you feel about that.
Yeah, it probably came to be by significant other telling the attorney that the guy's in trouble again, and this kind of happens. But interesting nonetheless. I have one update that we should mention while we're in the same vein. I know you and I didn't talk about it. Do you remember that DK Metcalf incident from the end of the season with the Lions, and he took a swipe at a fan?
Oh yeah. For sure. Yeah, they used his government name allegedly.
Yeah. So there. Yeah, I don't quite know what to make of it, but this fan has filed a $100 million defamation case. So we were thinking, and this guy's name is Ryan Kennedy. Was he going to file assault? Assault charges against Metcalf? The answer to that seems to be TBD. But he has filed a defamation lawsuit, a $100 million defamation lawsuit against Chad Johnson and Shannon Sharp's media company, as well as some other people that, and the lawsuit states in part that he was, quote, branded a racist in national media, close quote. So, $100 million is a large chunk of change. I'm not quite sure what this man Kennedy does for a living, but there was some allegations as to whether or not Kennedy used a racial slur to talk about Metcalf, and that's what precipitated the incident. So, again, I'm not in the business of treating every case like it's the Super Bowl, and we're following it really closely. But, we did talk about that in the past. We did say what the fallout would be. And, if we check the tapes, I think we alluded that this was possible. So here we are, Mike. And now Mr. Kennedy, similar to Brett Favre, has to defend against the ultimate defense, or has to face the ultimate defense of the truth is an absolute defense. And now we'll have to get ready for a defense that tries to establish that he said the N-word or whatever else he possibly could have said to DK Metcalf. So Kennedy has done the thing, and I guess we'll follow it if there's an update. But it's an odd case, so it is what it is.
Yeah, and they have, there's a lot of technology we've seen, that these stadiums have. So I'll be interested to see if that, that ever comes out, or what, if there's recordings of the situation and when that would be. But to this point, I mean, no one has technically retracted or made any like corrections, I don't believe. So maybe there's some ground. We'll see.
Yeah, it reminds me of that Mason Rudolph.
Myles Garrett, yeah.
Yeah, I'm just thinking it's basically the same thing. It's like Mason Rudolph was alleged by Myles Garrett as having said some type of racist remark that caused him to like swing the helmet at him. And we didn't really, kind of just fizzled out. And both guys stayed in the league, and I think cooler heads prevailed. But, now you're dealing with a player.
Yeah, and it's a fan that isn't, like, I think Mason Rudolph's made over, I would imagine, $10-15 million in his career. This is...
Well, it's funny. I mean, this guy was sitting like front row at the game. He's a season ticket holder. So, again, at least according to some reports out there, he's a CEO of some big company, and blah blah blah. Okay. Like, actually, you know what? I have a copy of the complaint here. I think as it was initially reported, like mainstream wise, it was just a defamation case. But actually, as you kind of unpack this, Metcalf is a direct defendant for the assault. So, and it looks like there's some other claims relating to premises liability. So, yeah, Metcalf actually got brought into this. So this is a weird suit, and that involves things like the assault, the thereafter defamation. I'm not quite sure those needed to be tied together, but I certainly see the assault and the premises liability tied together. But defamation might be a little too attenuated. But neither here nor there. But in any event, we will follow this. To the extent there is some interesting holding, we'll have an update. And if it just fizzled out and it gets dismissed, we'll probably tell you as well, because we're nerds, but don't hold us to it. Okay, Mike, I think we're good. Do you have anything else that we have not covered that you think we should?
No, I think we're good. There's a couple one-off stories that you'll get on ESPN. When it comes to some felonies. So I would say give it a run through on your feed. But otherwise, yeah, these are the big stories, and yeah, we'll definitely have some sort of understanding of the Chambliss story, I think, right before this goes out.
Okay. So again, getting some more tweets. It looks like Chambliss is going to win. NCAA's out. Whether they get held in contempt again, you'll see it in the headlines tomorrow. But that being said, it's always a pleasure to have you as our viewing audience again. To the extent you want to get involved with conduct in some way, shape, or form, let us know. Shout out to Taryn Sharma. Shout out to Mike Lawson. And shout out to all of you for tuning in every time we have an episode. I was going to say each and every week, but every other week. That being said, I think Mike, unless you want to round up the troops, I'm not going to be around next week. So if you want to round up the troops, by all means, if you're listening to this and you're a diehard listener and you want to get on the podcast, we've got an open seat next week. So, if someone is passionate enough, we'll find a way to get them on. Okay. That'll do it for us here at Conduct Detrimental. We will see you next time on another episode of